Hey, Judge.
Hi.
Law student.
Hi, come forward. Well, there's a seat for you there. Welcome back. Okay, sure.
I competed this weekend with bodybuilding.
Yes.
So the exception.
Oh my
I don't know
gosh.
what to do.
Congratulations.
Yeah.
All right. Well, I'll tell you what, and here in this court, we're trying to do the walk across Texas. So we're going to have to use you as an expert.
Yes. Yes.
Okay.
You're doing it for Luis.
Okay.
Oh, yeah.
All right. Thank you.
We love your photos. It's like, I love her.
Oh, thank you so much. But yeah, so you can have a seat there. This is another intern and you all guys can watch what's happening in court today. Yeah, sure. There's a chair. Yeah, you all can bring a second chair.
Thank you, ma'am.
All right, you're welcome. All right, everyone, I'm going to call the docket. Please let me know if you're here. Johnny Ramirez. Johnny Ramirez. John Bueno is in custody. Roland Diaz, Jesse Solis, Paris Farris, Juan De Hoyos are in custody. Gabriel Gobert. Thank you. In custody, Cornelia Childress, Thomas Henson, Latasha Jenkins, Elisa Marino.
Yeah, she's present.
Thank you. Mario Miranda. Thank you. Arturo Villanueva. Sarah Gutierrez. Luis Camacho. Raul. How do you pronounce that? Raul Parral. Raul Parral. In custody, we have Richard Rodriguez, Ricardo Tavares, Edward Valdez, Rogelio Lara, Annette Idro. Thank you. I'm sorry for mispronouncing your last name. I'm gonna work on that. Carlos Ruiz is in custody. Richard Rodriguez, custody. Kevin Curiel. Stephen Rose. Jeremy Garcia, custody. Victor De La Vega. And custody is Amadian Smith. Carlos De Leo. In custody, Jose Ruiz. Sean Chrisman. Is that on the docket today?
Yes, Your Honor.
All right. Is he to be here at 11?
Your Honor, I thought we told him I am.
All right, thank you. Nicholas Ramos is in custody. MC Reed. MC Reed.
President, on that one, Judge, the only number I have for him is the treatment center that he was at. I know he had a hard time getting here last Friday or last Thursday when I was out. I'll try to get a hold of them and see if he is on his way or.
All right, thank you. And in custody, we have Victoria Hernandez. Is there anyone present and your name was not called or you came in late? All right, yes. What's your name? I'm sorry, what? Do you have a case number or SID number?
Yeah.
1181855.
All right, do you know who your attorney is?
Attorney Hickey.
All right, just give us a moment, okay? Anyone else on this side? Yes. All right, we have you on the docket. What page is he on? I got it. All right, anyone else on this side? On this side, anyone who came in late or your name was not called? All right, everyone, these are the rules of the court. On this side are the boxes for criminal trial division. On this side are the files for family violence attorneys. As you know, I see people walking around outside with masks on, coughing. So it's flu season, pneumonia season, COVID season, leprosy season, which is coming in from Florida. So if you'll just grab your file, place it on the prosecutor's desk, and they will call you in the order of appearance. To my left, it's a court reporter. Please do not place any of your items on her desk. Do not lean on her desk. Her equipment costs over $10,000. If you damage in any way, you will have bought it. To my right is the probation officer. Do not sit on her desk. Do not place your papers on your desk. Do not turn your back to her. And right here is Deputy Laura. And that's where the inmates come out. Do not block that entryway. Do not block the deputy's line of vision. If anything happens and you're in the way, well, I guess I should say, oh, well, at that point, because I'm telling you, do not block their line of vision. Do not approach the court attorneys unless you confer with the state and confer with your client. If your client is an inmate, yes, they need to be brought out. Request your client. If they're an inmate, request it from the deputy. Once you've made that request, do not leave the courtroom, because due to security reasons, there are only so many inmates that can be brought out at a time. And if you request an inmate and leave, you're being selfish. If your client wishes to communicate in a language other than English, yes, we need an interpreter. Just ask the clerk to bring down an interpreter. Once you've done all those things and you're ready to approach the court, just ask the clerk to pull your file. I will call you in order of appearance. The only exception is if your client needs an interpreter. Do not approach the clerks or the court coordinator for continuances or resets. I'm the only person that can give you that. When we are on the record, if you are in the box speaking with your client, do not speak behind the court reporter. Just ask the deputy and they will move you and your client to the other end. All right, everyone. Today is Monday. I spoke to a deputy and he said, it would be great, except it's Monday. But if we started on Tuesday would be that Monday. So let's make today a great day. We're all currently alive, so that's a good thing. So please confer with kindness in your hearts and have a great day. Thank you.
Judge, may I approach?
Yes, you may. Are you on the docket?
Yes, Your Honor, for sentencing on Johnny Guy Ramirez, and he just walked in.
All right, thank you.
Thank you.
Okay, so Deputy Laura. I ended up going to a veterans event over the weekend. It was awesome. Of course, I go every year, but every year there are more opportunities for veterans to have free stuff. I wouldn't even call it really free because they serve the country, they deserve it. But there are so many programs out there, and I've learned about a couple of programs, new programs. So I'm going to see if we can get them to come to this court. And they gave me flowers. I'm like, oh, thank you. But they are so great. Guess what they did? They put their flowers in individual little water. They have their own little individual water cubicle. So when I give you guys flowers, it's already watered. So it's like, yay.
Yeah. September 20th.
I'm trying to think. It's going to come to me. Yes. Okay. Oh, awesome. So great. Oh, no.
I'm busy and I work.
Oh, if you can do it.
Yeah, that's what
We're ready.
Thank you.
And actually just.
All right, Mr. Featherston. Robert Featherston.
Yes, Your Honor.
Hi, are you ready?
Yes, we are.
Do you need a moment?
No, Judge, I just got what I needed.
Okay.
I'm going to ask the court for another continuance, and the reason why is Mr. Ramirez has a daughter that has a brain issue.
Mhm.
And
Yeah.
they were evaluating her last setting, so we got a little bit of extra time for them to finish the evaluation. They did not do surgery last time. She had seizures again this morning, and they have to take her to Houston on November 3rd for evaluation for brain surgery. And it's completely up to the court as to whether.
We'll go on the record.
All right, Judge.
All right. All right, Mr. Johnny Ramirez. All right, court is calling 2023 CR 6932, State of Texas versus Johnny Guy Ramirez. Can I have parties announced for the record for the state
Hank Wilkins, Judge.
defense?
Robert Featherston.
All right, we're here for Johnny Ramirez for sentencing today. Off the record, defense counsel was telling me that he was going to ask for a continuance. Did you file a motion or no?
No, Judge, no motion was filed. I literally just found out that the surgery has not yet taken place.
All right. State, any objection to the defense's oral motion for continuance?
No, Judge.
All right, court will hear argument.
Your Honor, if it please the court, the child has an appointment in Houston for evaluation for brain surgery on November the 3rd. We're respectfully requesting that the court allow him to come back November the 10th
Mhm.
for sentencing. He's already been admonished that the full range of punishment is available if he doesn't appear for sentencing.
All right, so state, are you going to have any objection?
Just the same admonishment, Judge, the full range, and I would ask the court to remind the defendant that if you are inclined to grant this, that's the day.
All right, so here's my question. Counsel, you're an officer of the court. Do you have proof of this? Proof of the fact that there is a brain issue with his daughter? Do you have proof?
Judge, I have not had any independent investigation on my part. The representations made by his wife of what I am relying on, that the child has to go to Houston on November the 3rd.
All right, so with regards to her issue, does anybody have any medical documentation whatsoever?
My wife does.
All right, so let's, he says his wife has medical documentation. Counsel, if you could go take a look at that documentation and tell the court if it appears to be true.
Thank you, Your Honor.
Yes. So usually what ends up happening in cases like this, sometimes defense attorneys don't have a chance to file a motion for continuance because they learn of things right away. Now, some judges, they will say, absolutely not. You need to file a motion for continuance. But sometimes if there's an issue where maybe it's something that just happened, there's no way they could have known about it, I'll let them go on an oral motion unless the state says you can object to it, because legally, you're supposed to have a motion for continuance filed. And that motion for continuance has to be sworn to by attorneys, either the state or the defense. Either one of them file a motion for continuance, they have to swear to it. So whenever I have attorneys saying, I need a continuance, and the state allows them to go orally, if they're saying, oh, my client has this happen or that happened, I want to know if they've investigated themselves. Because sometimes people will say, oh, this is going on, and then it's not going on. So because all attorneys are considered officers of the court, that we're not gonna be untruthful, I always ask them to go investigate. So now we're gonna find out if there's any type of documentation they have that there's a brain injury. For me, if they're saying it's November 3rd, I'm gonna accept that as true. But first, I need to see if there is an issue, because we've been here before for this. Now, some judges would say, that's my problem. You're going into custody day, because that's what his agreement is, you're going to custody. But to me, everybody is a human being. I don't want to be the one that, you know, maybe his daughter is going into surgery and she would like her father to be there to kiss her or whatever. I don't want to be the one to say, oh, not gonna allow that. To me, that would be very hard. And it would be different if this were a violent offense that he's charged with, but it's not a violent offense. So that's where we are. Oh, well, usually attorneys, they just file them. Like, sometimes it's the same day. And I know that's why I always tell people, you need to come to court and see how things really work. Because sometimes it's whatever can expedite things. For example, sometimes it is motions for bond reduction. People always tell you in college, oh, you need to file a motion to have the bond reduced. But sometimes attorneys just come before the court and they have an agreement and they do that. All right, we're going to go back on the record in 2023 CR 6932. Oh, if you can come forward, Mr. Ramirez.
Your Honor, please report, I'd like to call Valerina Flores, the child's mother.
All right, so I know you're going to call her as a witness, but, and I will hear from her, but is there any documentation that you've seen?
I believe there is, Judge.
Okay.
The terminology is medical terminology. It doesn't say brain surgery, but it does list her maladies.
Okay,
If the court will allow me, she'll bring up the online medical record and can tell you what the different diagnoses are.
all right, we can bring her up, but counsel, I mean, you've looked at it, I'll take your word for it, but if you want to bring her up as a witness, we can.
Well, we might as well get on the record what those maladies are.
Okay, sure. And what is her name?
Valeria.
I'm sorry?
Valeria.
Valeria. All right, thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Valeria Flores.
All right, defense.
Ms. Flores, if you would take a look at the online record in the section where it lists what the evaluations are on your child. A little further down. Right here. Can you read those out, please?
She has left hemiplegia.
All right, just 1 second. Let's do this. If you can move closer to the court reporter.
Okay.
And when you state whatever you're stating, if you can spell it, that'll
Okay.
make it easier for her. Okay.
Okay. Left hemiplegia. It's LEFT. Hemiplegia is HEMIPLEGIA.
And just spell it a little slower.
HEMIPLEGIA.
Yes.
Seizure disorder. Left hemiparesis. Left, and then hemiparesis is HEMIPARESIS. Cerebral palsy. Closed fracture of shaft of right clavicle. Closed fracture of shaft of clavicle. And then elevated blood pressure reading without diagnosis of hypertension.
Your Honor, to please support, those are what are listed in the medical records.
All right. Thank you so much for letting us know. Okay.
Right.
Your Honor, may she be excused?
Yes. Oh, I'm sorry. When is the surgery, or when are you all scheduling things?
We just did a 48-hour EEG to determine where her seizures are at, and come to find out it's her entire brain. So November 3rd, the doctor wants to talk with us with a colleague in Houston.
Mhm.
just to get a better understanding of what type of surgery they're gonna perform.
All right, and how old is she?
She's 16.
All right, we're gonna be praying for her.
Thank you so much.
You're welcome.
Thank you.
All right.
If we could go off the record for a moment.
Thing that needs to be done is the plea page.
Yes, ma'am.
So if you guys want to just print that out and write that in, you can.
Thank you.
Oh, and counsel, the application.
We'll do.
All right. But yeah, so sometimes when things happen, I know how it appears on television that people have this big law firm and they can call somebody and say, hey, I need a motion to continue now, or I need this bond issue now. That's not how it happens in the real world. In the real world, usually attorneys are solo practitioners. They have more than one court to go to. They'll go to a second court or a third court. So they have all these courts on their docket. So they don't have somebody at the office because they're the person at the office. They're the secretary. They're the person who answers phones. So usually, unless it's a jury trial, the motions for continuance are usually not typed out or written because nobody knows. Now, if you're having a jury trial, you know it's a jury trial and you know you're going to be asking for a continuance, so you should already have that motion done. So things like that, I tell them, no, you need to do a written motion. And sometimes attorneys will write it out, but then if they write it out, they have to go and find a notary, which is hard. When I first started practicing, a lot of the coordinators were notaries. And so people would go to a coordinator, hey, can you swear me in? And that's an extra fee at the courthouse. It may have risen to $5 or something just to get something notarized. So it's always good as an attorney if you want to be a notary too. Yeah, and then you can just be around the courthouse. Oh, I'm a notary. But then if you're a defense attorney and you're a notary and you charge an attorney, all the attorneys will say, can you believe that attorney charged me? Yeah. And in other countries, their notary does more than just swear people in. Because I used to put together a lot of international CLEs. So their notary has more power, like what attorneys actually do. Their notary can actually do that. So they do more than just, oh, come before me, swear me in, let me sign you in. Yeah. All right, Raul Paral. Edward Valdez. All right, sir, you need to go on the front row. You were late. MC Reed. All right, thank you. Sean Chrisman. So usually I give people about till 10:30 to make their appearances. And then after that, a warrant may be issued. I don't like to do it before then usually because it's a lot of paperwork for the deputies, for somebody to then to come in and say, oh, I was in a car accident or this happened. And then they have to undo all the paperwork because there's a lot that goes into issuing a warrant for somebody. The deputies have to do their paperwork, then the clerks have to put it in the system. And once it's in the system, of course, this is the government. It takes a while to get it out of the system and calling the bondsman, see if the bondsman will get back on the bond. It's a whole host of things that happen. Mhm. Oh, if there's a death or something of that nature. Oh, their attorney will usually let me know, and I'll ask the attorney, do you have personal knowledge of this, or is this something somebody told you? And then sometimes people will say, oh, I got pulled over by the police, and they'll come in with their ticket. I had a client once who was late for court every single day. So the judge asked us to come back at 1:30. And I tell him, you are going to go to jail if you are late. So I'm there at 1:30, 2:00 passes, 2:30 passes, and then he finally shows up and he's just all jovial, like there's not a problem with him. I'm like, you are going into custody. What happened? And he said, oh, I got a ticket. And I said, do you have proof of this? And he showed me his ticket. And guess what the ticket was for? Jaywalking. It's like I was rushing to court. And so I had to show it to the judge, but he didn't go into custody that day. Hello.
Good morning.
Good morning.
I'm here on Edward Valdez, case number 2023-72708.
Mhm.
I appeared, but apparently he has not.
No, he's here.
Is he?
Edward Valdez.
There he is.
Yes, sure.
Thank you.
Caroline, on this one, they're going to do some extra paperwork on that one. Richard Rodriguez. All right, Mr. Rodriguez. Hello, Mr. Rodriguez. Oh, I'm doing great. How are you doing today? Okay. All right, today is your plea deadline date. So this is the day where you let the court know whether or not you're accepting the state's offer or not. You understand? All right, so do you want a jury trial? Or are you accepting the state's offer?
I'm not gonna accept the state's offer.
All right, so you want a jury trial? All right. How long do y'all expect this trial to last?
2 to 3 days, Judge.
And he's not 2 to 3 days, he's saying 2. All right, and I've known Mr. Callahan for how many years? And if he says 2, yeah, if he says 2, it's 2. All right, and I'm assuming you all will be proceeding on the first degree, is that correct?
Yes, Your Honor.
All right, Ms. Ferguson? They need a jury trial and it's for 2 days.
For December 5th.
All right, Mr. Callahan, December 5th?
Yes, ma'am.
All right, we're gonna put you at December 5th. We don't have juries the week of Thanksgiving and our docket is booked, okay?
Yes.
All right, so that's the quickest I can get you in. All right, is there any discovery issues? I know last time there was not.
No, Your Honor.
All right, if you all do a discovery acknowledgement before you leave on the 3 cases,
Yes,
and
Judge.
then just let Mr. Callahan know which case you're proceeding on.
Yes, ma'am.
All right, thank you.
Excuse, Judge.
Yes, once you sign the discovery acknowledgement.
There you go. Oh, no.
All right, so since you're saying that trial is going to take 2 days, and usually Mr. Callahan always estimates very correctly. So with a 2-day jury trial, that means that we'll probably select a jury on that day. And then the next day, they'll do their trial and they'll be done. Yeah. Okay. Yes. And I always tell people always assume that I know what the cases are about, but the only thing I know is what the charges are. I haven't heard any facts or anything, and I won't, when the jury is hearing what people think the facts are, is when I hear what the facts are. So unless they do a motion to suppress everything, I'm hearing it for the first time as well. Mr. Callahan, are there gonna be any motions to suppress or no?
Oh, Your Honor.
Okay, all right, thank you.
Yes. I don't have to do that. But I think. And I don't know if that's-
And so because of all of the health issues that people are having, I try to keep the courtroom as least congested as possible. So the way for transparency and open it up is to have it live. So that's what I try to do. And hopefully people will learn about our justice system, about the process, and why it's so important for people to be present for jury trials. Because that's one of my pet peeves, when people try to purposely get out of jury duty. I remember one time I scraped my money together to get a flight home for Thanksgiving. And I got called up for jury duty. And I so desperately wanted to say no. So I didn't cancel my ticket. I was just praying, please don't let me get picked. And then I was saying, who would have jury selection, when it's a holiday upcoming? And so sure enough, I got lined up to go to the court. I'm like, yeah. But what ended up happening, we were out in the hallway, and then the state ended up dismissing the case. So I was able to go home for Thanksgiving. Yeah. But so I always tell people, please do not try to get out of jury duty, because everybody's depending on you.
No, it's important.
Oh, yeah. And I always tell people, like you say, the complainant is dependent on you. The person who's accused is dependent on you. And I love when a jury is out deliberating late, even though people will say, I can't believe people are deliberating that long. It's very clear. But I like when jurors are out for a long time, because that means that they're going over everything and discussing things. I don't like when jurors come back very quickly. I mean, of course, if they come back quickly, they're like, oh, there was a video, there was this, that's fine. But I really like when it appears that they're going through every piece of evidence. And I will tell you, in this court, I don't think, I could be wrong, maybe we've had maybe 1 or 2 fast verdicts. But usually after the jurors come back with their decision and the attorneys go back and talk with the jurors, they have thought a lot about things and they've looked at everything and gone over evidence. So I appreciate when they do that. And I know the defense and the state do. And when a jury tells you, hey, this is what we considered, this is why we did what we did, knowing that sort of makes the defense attorneys feel great and makes the state feel great. Even if you get a guilty verdict or not guilty verdict, they're saying, hey, I had a fair shot. Mm-hmm. 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 Yeah. Mm-hmm. Oh, it is. Mm-hmm. Oh, yeah. I think that students, honestly, I think students and the public, everybody should come down because what actually happens in a courtroom is completely different than what people think. Because sometimes people say, why does it take so long? But you can see everybody is negotiating and talking about different things. And they don't talk about things beforehand. Because guess what? The state has hundreds upon hundreds of cases that they're dealing with. The defense attorneys has hundreds of cases that they're dealing with. I would always tell my clients, I had some clients in custody and every weekend I would go visit them at the jail. Even if nothing was happening with their case, I would go visit them so I could tell them, I haven't forgot about you. I know you're here. Sometimes we would end up talking about just what's happening in the world because nothing was particularly happening with their case. And I would always do that because sometimes none of them had their family members to come visit them. And also, again, I wanted them to let them know, hey, I still remember you. I haven't forgotten about you. And what I would explain to them about their cases, because they would say, I want it done now. I want it done now. I would tell them, consider your case food. They're like, okay. I'm like, you're in the freezer. I said, there are some people in the refrigerator and there are some people who are in the sink thawing out. And I said, right now I'm in trial. And I said, you know what? That person is on the stove and I got to make sure that it doesn't bubble over. I said, at some point, you're going to be out of the freezer and you are going to be on the stove and you're going to appreciate that I'm making sure nothing bubbles over. So I would explain it to them that way and they'd be like, oh, okay. And so, but the one thing that I learned as an attorney, when you do this for so long, you forget to tell your client, oh, you're not going to prison. You know, it would, something strange would happen if you would go to prison because you would learn on what cases maybe your client is in jeopardy of their freedom and what cases they were not. So I remember it hit me when I had one client and they were so nervous. I'm like, why are you so nervous? They're like, oh my gosh, I could go to prison. I'm like, oh, I'm so sorry. I'm like, that's my fault. You're not going to prison. Because you don't think that, because you do stuff so much till you forget to tell your client, this is not a prison case. You're not worried about it, that it's a prison case, but they are. And so I had to readjust and say, Stephanie, you remember when you first started out and you would let your client know, this is the realm of possibilities. So it takes a lot. Yeah, so that's what happens. Yeah. Well, you know, yeah, oh, they do. Well, you know, part of the problem is I did, the majority of my practice was criminal law, but I also did civil law as well, because a lot of those cases turn into criminal cases. So I would get appointed to represent people over there. And you would be shocked. Sometimes I would represent children and they are 16 or 17. And I would say, what are your hopes? What are your dreams? And they don't have any. They say, nobody ever asked me that. And I would say, okay, we're going to figure out what your hopes and dreams are. We're going to figure out how you can accomplish that. Sure. Mhm. Mhm. Oh, yeah. All right, I'm going to make sure that I'm going to see how many students want to do it.
Thank you.
Well, you would be surprised. A lot of people want to be in general population, even if they think there's some fear to their safety. They want to be in general population. Just.
Yeah, yes, yes. They allow that to go on.
All right. So a lot of them, they want to be in general population, even if they think there's a fear to their safety. And the reason why they want to be in general population is because they have more freedoms. When you're on lockdown for about 23 hours. And then you have that hour, and in that hour, you have choices to make. Shower, walk around. And if you go to the jail, I know people will think prison is like, or jail is, oh, you get to go outside, smell the fresh air, do whatever. But when you're on lockdown, they have a room. And that room is not as big as this courtroom. And on the top is fencing. So you can see the sky, but it's covered by fence. And there's this small little area. And that's it. And it's extremely dark. And I try to tell people, when you send people to the Bexar County Jail, when you send people to the prison, depending on what their charge is, the range of punishment, at some point in time, they're going to be released from prison. They're going to release from jail. Are you releasing them from prison and from jail better off or worse off than when you put them in there? Because a lot of people focus on punishment, which, yes, it's a part of punishment. But then when they're released, hopefully you're thinking they're rehabilitated and have made plans on how they're not going to go back. Because with all the people who are charged with drug cases, it's rare nowadays for people to get life for drugs, right? Yes. Hi. Yes.
I'll write it down.
But I will tell you, I did go to a drug court graduation, which I always go to those if I'm here and if I can make it. And there is a graduate who is now an attorney. So even though I always tell people, you need to do your research before you spend all the money, it takes a lot of work to get your license if you have a felony. But it can be done, but it's just going to take a lot of work. Because we had some classmates from my class who actually had to go before a board because they had things in their past. And they do a fingerprint when you go through law school and you're getting once you pass the bar, that's not the end of it. You have to do a fingerprint and then they run you through all the systems. They do an FBI check to see if you will be great for it. So it's interesting. Mhm. 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 Mm. Yeah. Yeah. It's difficult. Johnny Ramirez. Court is calling 2023 CR 6932, State of Texas versus Johnny Guy Ramirez. Can I have parties announced for the record for the state?
Hank Wilkins to the state, Your Honor.
Defense?
Robert Featherston representing Mr. Ramirez.
All right. Are you Johnny Guy Ramirez?
Yes, ma'am.
All right. It's the court understanding is that both the state and the defense have entered into a new plea bargain agreement. Do you understand that?
Yes, ma'am.
And is that correct, state?
Yes, Your Honor.
Correct, defense?
Yes, Your Honor.
All right. So the same admonishments that I've given you before apply. Do you understand?
Yes, ma'am.
And are you waiving your right to trial?
Yes, ma'am.
So with regards to the enhancement, which enhancement is he pleading true to?
It's the first, in the paperwork, it's the first one, Judge. It's cause number 2013 CR 1015.
Right. And how do you plead to that enhancement? True or not true?
True.
All right. With regards to the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes.
All right. So according to the plea, you agree that you've been previously convicted of enhancement. Paragraph 1, the punishment is to be assessed at 10 years in the prison. The state is silent on your application. Did you understand that to be the case?
Yes, ma'am.
All right. And defense, is that the plea?
It is, Your Honor, with this application for deferred.
All right. And state, is that the plea?
Yes, Your Honor.
I'm going to show you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
And then state, it's the court understanding as well. And we're going a little bit out of order here because there's been a new plea bargain agreement reached. But state, are you offering into evidence state's exhibit number 2, which is the judgment?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
All right. And outside the agreement, the state is requesting a TAP evaluation. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes.
All right. You previously pled guilty. Do you still wish to enter a plea of guilty?
Yes.
All right. State, do you have any evidence to support this plea?
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection, Your Honor.
All right, the court has previously reviewed that. Mr. Ramirez, do you understand the previous admonishments that the court gave you with regards to State's Exhibits 1 and 2?
Yes.
All right. The court has reviewed State's Exhibits 1 and 2. The court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Do you understand that in regards to your application for deferred adjudication, if the court were to grant that, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Knowing that, do you still wish to apply for deferred adjudication?
Yes.
All right. Is there anything you wish to say on behalf of your client?
Judge, the court and the state are both being very kind. He has accepted responsibility for his actions in this case. And we respectfully request that the court follow the plea agreement and give him a deferred.
All right. Are you employed?
Actually, no, ma'am, I'm not right now.
All right.
Take care of my kids at home.
I'm sorry.
I'm taking care of my kids at home,
All right. How old are your children?
2 and 3.
And the 16-year-old?
She goes to school. She goes to school, and my other daughter goes to school too.
All right. If you're drug tested today, what are the results going to be?
Well, I am still dirty.
Dirty for what?
For both meth and for marijuana.
All right. So you shouldn't still be dirty for meth and marijuana since this plea was originally taken on October 13th. So it's clear to the court that you have a drug problem.
Yes, I guess, and nobody's ever given me no treatment.
No. We're doing this one step at a time.
Okay.
So you have a drug problem.
Yes, ma'am.
Your problem is with meth. And you're not any good to anyone if you're using meth. You're not good to your daughter who has this brain issue and that's going in. You should not be allowed to be taking care of a 2-year-old and a 3-year-old. And I'm not going to allow that.
I don't do it like when I take care of them and stuff.
No, right now, you should not be allowed to take care of 2-year-old and 3-year-old. Let me ask you this question.
Yes, ma'am.
Let's say you need a babysitter, right?
Yes.
And somebody has recommended me to you. I come out, I meet the family. Everybody says, oh, Stephanie's great. So I come out to your house and you and your wife say, you know what? We're going to see if the children like her. Children love me. I'm the Black Mary Poppins. You all take a break. You said, we're going to test her. We're going to turn on cameras and we're going to tell her we're going to the store. You go to the store. I'm still the same great person. And you come back and the children like, please, can we keep the Black Mary Poppins? And you guys say yes. So you all decide to hire me. And I'm like, oh, I'm so excited. And then as I'm walking out the door, I said, you know what? You guys seem like a nice family. Your children are nice. Let me just tell you something about myself that nobody knows. And I tell you, I use meth and marijuana, but don't worry. I'm not going to use meth and marijuana over the children. I will do it before I come. Are you still going to let me be a babysitter? I'm sorry?
No, I wouldn't.
That's what you're doing. So I'm not going to allow it.
I don't want. I pick all that stuff.
So you're not going to be allowed to take care of a 2-year-old and 3-year-old. You understand? And you need to get a job. There's no excuse for you not having employment. And if you're on deferred out of this court, I require people to have employment. And would your wife test positive?
No.
So here's the thing about that. Your wife then, since she won't test positive, she's holding everything down by herself. She has employment. She's dealing with her daughter who has these medical issues that she has to take to Houston. She can't depend on you to drive to Houston because you're using meth and drugs. She has a 2-year-old, 3-year-old. She can't depend on you. So right now you're not bringing anything to the table. But when you're on deferred adjudication out of this court, you're going to bring something to the table. You understand?
I'm sure I will. Change.
All right. It's going to be 10 years deferred adjudication. We're going to do a TAP evaluation. And he's going to follow TAP recommendations. So if it recommends inpatient treatment, you're going to inpatient treatment. And the fact that your daughter has a medical issue, you're still going into inpatient treatment. You understand?
Yes, ma'am.
And counsel, if you can see, maybe Lifetime Recovery will accept him into their inpatient program.
I'll check on that, Judge.
All right. There is going to be the UA hotline. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Doesn't matter if it's your child or not, you're not to have unsupervised contact with them. So there needs to be an adult if you're going to be there. And if the adult says, I need to go to the grocery store real quick, you take care of the children, you better tell them no. You understand?
Yes, ma'am, I will.
I'm going to want field visits one time per month until further notice or until he's at the Lifetime Recovery Residential. Regular reporting by Zoom or in person. $200 hours of community service restitution. That will be waived upon completion of parenting classes. And probation, whatever parenting classes you all deem is necessary. All right, probation, is there anything else he needs?
No.
All right, is there anything else you need from this court to be successful? Do you need anything else to help you not come back here for a revocation? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, so off the record. From here on out, everything you do in your life, you know what you need to ask yourself some questions before you do it. One, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. The only reason why you have this agreement before you right now is because of your daughter's medical issues, not because of anything that you have done. So you had better take this opportunity to do better and not use drugs. All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
Probation. Here's your,
Frank Torres. Hello, Mr. De Leon.
morning, Your Honor.
Good morning. How are you doing today?
I'm doing peachy. Mr. Torres was a recall from last week, Your Honor.
Okay. All right. So what are we doing with Mr. Torres?
Work with the state, we want to just set the case for trial at this point, Your Honor.
Okay. Has an offer been tendered?
Oh, yes.
All right. How long do you expect this trial to last?
It's a relatively short, so 2-3 days.
All right. Ms. Ferguson. On this case, jury trial, they say 2 to 3 days.
I can do December 4th.
All right. December 4th.
Yeah, will work, Your Honor.
All right. You'll be back on December 4th for your jury trial.
Yes, ma'am.
All right. Thank you.
Thank you, Judge. Are we excused?
Yes, Mr. De Leon, I received an email and Ms. Ferguson received it and the state was included in it. You were asking for a case to be moved on a different date?
October 30th is Christopher Gonzalez in this court.
Mhm.
I'm gonna be in trial on the 399th impact, I believe.
Okay,
So to have, just to move things along a little bit quicker, I was trying to see if we can move that off for at least a week or so.
okay. So do you 100% know you're going to trial or?
Unfortunately, 99% yes, unfortunately.
Okay. All right, if you'll grab the file from the back.
There's someone in the back.
Okay, let me see. If you can give her the cause number.
Sure.
All right,
Christopher Gonzalez. October 30th.
let me see.
I'm ready to move. It's a hearing for discovery. But Brittany's 175. I think so. He's here. I think Brittany's a 175.
Here we go. I don't think this is on the docket. Okay. Okay. So yeah, a lot of times it's wait for people to come and confer and then see what we're doing on these cases. Oh, that happens a lot. But we try. There's still some new things that I haven't seen, so. Oh, sure. You're welcome. Yes. Let me see. Okay, I'm looking. I don't, let me see. No. And let me search your name. You're talking about the capital murder voucher?
Yeah, that's the one. Okay.
Okay. Yeah, just print it out.
I can print it.
Oh, okay, I'll print it. I mean, are they automatically sending capital murder vouchers to them? I said, are they automatically sending capital vouchers to them?
Go directly to the.
Ah. Okay. All right, defense attorneys. The court has been informed when you're on capital murder cases, because now my understanding is it's e-file. capital murder cases for vouchers are not supposed to go to the MAC. But if you e-file it, it automatically goes to the MAC, then it comes back to me. So if you can go forth and tell your colleagues for the capital murder things, don't e-file them, just write it out, print it, and bring it to the court, because otherwise it's going to be extra time in your pay, because it's going to go there and then it's going to pretend like we automatically sent it there when we did not. So please let your brethren know. Okay. All right, can you call Orlando, see if he's in the building, see if he can come over, please. Tell him it's a capital murder voucher.
He's not in the building.
Oh, we'll see if he can come over. Tell him it's about his capital murder voucher. Okay.
Thank you.
All right, thank you. Norma, when do you want to call back? Christopher Gonzalez. And when is your jury trial? Because I know this one is set for trial as well.
Yes, got October 30th.
So that's your jury trial.
Jury trial.
All right, state, this is your case. So he says he's going to be in trial. And is it specially set there?
It's not specially said, but it's old and it's right.
And which court?
399.
All right, and you're 100% sure it's going to go?
I'm 95% sure.
95, okay. 95, not 99.
Last time it was supposed to go and we got bumped.
All right, so that's set for October 30th. And when is this case set?
It's set in here on October 30th, Judge.
All right. So, Ms. Ferguson,
Yes, ma'am.
what date are we coming back on this?
It's the same date as the other pledge we asked on December 4th.
All right, we'll put it on December 4th.
Okay.
Okay. All right, and you're able to get in touch with your client?
Yes. Okay. He always calls.
All right, thank you.
Sounds good, Judge.
You're welcome.
I think that's all I have today. Maybe
Oh,
excused?
yes, have fun.
You too.
Hey, hopefully we get some cold weather. All right, John Henry Bueno. All right, counsel, did you get your,
Did not, Your Honor. I just talked to probation. They said they're having issues with their counsel.
Your Honor, we did send an email that had the subpoena
Mhm.
in it to our general counsel last Tuesday, and we just have not heard back yet. We have put out a filler to see what's going on, and that was this morning.
all right, so who's the general counsel?
Which I don't know their names, but
All right, let me see. All right, let's call her. Let's see where their emails are. So he wants emails between his client and probation, or what they sent him by email. And so there needs to be their general counsel to say, yes, we'll turn it over, but they'll only turn it over with a subpoena. So they said they will respond to a subpoena by email, which makes things go quicker. So now they're going to call their general counsel to discover where the emails are. And if they say that the general counsel says, oh, we are going to respond to that email, it shouldn't take that long to get the emails. So that's where we are. Oh, you should probably ask the coordinator. She'll know. Yes. Yeah. Okay.
Okay.
Bingo out. It's a repeat. Yes. Oh, you know what? You're right. Thank you. Caroline, what are we going to do when you leave us? Raul Paral. Raul Paral. Sean Chrisman.
Approach.
Yes,
I know I'm on YouTube.
yes, what's,
I know on YouTube because it says it is.
Mhm.
Anyways, you had, I'm sure you read it, just, did you need it in paper or not scrapbook or?
oh, I don't keep anything for scrap. My mom always gets something made of
Send it to
that.
your mom.
All right, thank you so much. I appreciate it.
What's so? Step. So no one's. Deadline is possible. Really well. No. Oh, no. Yes. Yeah.
That was, that's your spend that I.
Ah,
That's- Sir.
No more dire. Thank you. Yeah, very, very.
You should probably talk to the state. Yes. Okay, sure. Yes. Eduardo, look at me changing it to Eduardo, Edward Valdez. See, I'm thinking my pronunciation was gonna be good. All right, so an offer was due today. Has the offer been tendered?
Yes, Judge.
Okay. All right, Mr. Valdez, do you need time to think about that offer?
Yes.
All right, Ms. Ferguson. On Edward Valdez, if we can call it back in 2 weeks for a plea deadline date. All right, we'll come back on November 13th. And at that time, you'll need to let the court know whether or not you're accepting.
Judge, I
yes.
have a doctor's appointment that morning.
Okay, sure. Normally, let's do it before the 13th,
I can do the 9th.
November 9th. Is that good for you, counsel?
That'll work, Judge.
All right, so we'll bring you back on November 9th. At that time, you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
Any questions about anything?
No, I appreciate it.
All right, thank you. Once you sign the reset form, you're excused.
Just have a seat. Thank you, ma'am.
All right, everyone, the court is breaking at 12.
That's scary.
MC Reed,
Second cousin to MC Hammer, Judge.
there you go. All right, so has an offer been tendered?
Yes, Your Honor.
All right, was that tendered today?
I think it's the first time we've spoken about a judge.
Yes, Judge. I believe that's the first time I've seen that offer in the file. So we reset from the last setting in order to get, he's on parole. In order to get more clarification on what he can and cannot do in order to not mess up on parole. We've gotten that clarification, spoken to the state. They need to look further into it before they can make the offer that we're asking for. So we're just asking for a reset to give them that time.
All right, and how long is that gonna take?
I think a month would be reasonable, Judge.
And if they get me the offer in the meantime, the offer would end up being a plea to the misdemeanor and a dismissal on this. So we'd end up getting that set. That way we wouldn't even be back in the next setting on this one.
All right, Ms. Ferguson on MC Reed, if I can have a 30-day reset.
Yes, ma'am, the 27th.
All right, we'll come back on November 27th. Once you sign the reset form, you excuse, Mr. Reed, you need to make sure you're on time next time, okay?
Yes, ma'am.
All right. So what does the MC stand for? I know we had this discussion.
It's my real name. I'm a junior.
Oh, okay,
Okay.
awesome. But see, I always think that letters MC have to mean something.
In most cases, they do stand for stuff, but in my case, I guess the generation that was before me, they just use letters sometimes.
Okay.
JB or JL.
Ah, okay. Now, when you said JB,
Yeah.
I understand now.
Yeah.
Okay, awesome.
Yes, ma'am.
All right. Once you sign the reset form, you're excused.
Thank you, Judge.
All right, you're welcome. Ricardo Tavares. Hello. Court is calling 2023 CR 7145, State of Texas versus Ricardo Tavares. Could I have parties announced for the record for the state
Jason Garrett, Your Honor.
defense?
For the defense.
And are you Mr. Tavares?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tavares, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 1, 3, and 4, and proceeding on count 2 alone.
Any objection?
No objection.
Mr. Tavares, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That is a second-degree felony. Off the record for a moment. Probation, this is no application. And we're back on the record. The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Tavares, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Honor. Yes, Your Honor.
According to the plea, the state is proceeding on count 2. There are no applications, and they're asking that your punishment be assessed at 3 years in the prison. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state,
It is, Your Honor.
showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There were none, Judge.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State Exhibit number 1 with all the attachments.
We have no objection.
All right, state, you may continue to confer. Showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding in sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just ask to follow a plea agreement.
All right, court will follow your agreement. The court will sentence you to 3 years in the prison, give you credit for any time served. Is there anything else with regards to sentencing?
Nothing further, Your Honor.
All right, Mr. Tavares, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 35.
All right, do you have any children?
Yes, I do.
All right, here's the thing. You know that life keeps getting short for people. I can say that I'm in the twilight of my life. You're going to have to make a decision on if you're going to change or if you're going to spend the rest of your remaining time on this earth in and out of jails, in and out of prisons. I'm sure your children would love for you to be clean and sober in their life. If there's a drug or alcohol problem, there are plenty of free places. If you would like, I could actually have you referred to the therapeutic community at the prison. It will not increase the length of time that you're in prison. So for example, if they're going to parole you at 2 years, they're not going to say, we're not going to parole him because he's in the therapeutic community. It's just something to get you on the right track. Would you like that?
Yes, Your Honor.
All right. Caroline, can I see the following Tavares again? All right. Well, good luck to you. Okay.
Thank you.
All right. Good seeing you. Yes. Victor De La Vega. Who's the attorney for Victor De La Vega? Cornelia Childress. Thank you. I love the pen. All right, so Cornelia Shalom Childress, if you'll come down, please. Court is calling 2023 CR 0923, State of Texas versus Cornelia Shalom Childress. Could I have parties announced for the record for the state?
Jason Deerhead, Your Honor.
Defense?
Melissa Christian.
And are you Cornelia Childress?
Yes, ma'am.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cornelia Childress who was placed on community supervision in 2023 CR 0923 for the offense of felon in possession of a firearm on May 30th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1 on or about the 24th day of August 2023 in Bexar County, Texas. The defendant Cornelia Shalom Childress committed the offense of possession of a controlled substance, penalty group 1, in violation condition number 1.
How do you plead to that? True or not true?
No contest.
Okay, true.
I'm sorry. So to violation of condition number one, how do you plead?
Sure.
Right.
We'll waive the remaining violation.
Any objections to state's waiver? All right, did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, find you guilty, sentence you up to 4 years in the prison and up to a $1,500 fine?
Yes,
Knowing that you still wish to plead true to violation of condition number one.
yes.
Court will find violation of condition number one true. Is there a proposed agreement?
There is. It is to revoke the individual offer of probation and to reform the underlying sentence of 4 years to 3 years in Texas Department of Correction, and the state will take into consideration cause number or nightmag number 726-987 that she pled true to.
All right.
That is our agreement, Judge, and we'd just like to tell the court that she has 284 days credit that she would like to add for.
All right. Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. The court is going to find violation of condition number one true. Court will grant the motion, sentence you to 3 years in the prison, give you credit for any time served, take in consideration nightmag number 726-987. All right, if you all are behind, I make this announcement every time. If we're on the record and you're behind the court reporter, just ask to move to the other end. All right. Ms. Childress, I pronounce sentence. If you would like, I can ask them to refer you to the therapeutic community. It doesn't increase the time that you're in custody, but it could potentially help you get on track with your life. Would you like that?
Yes, ma'am.
All right, so I'm going to order the therapeutic community. You'll still need to ask for it when you get there because I have no jurisdiction to force them to place you in the program.
Yes.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. I see that I ordered parenting classes for you.
Yes, ma'am.
You are going to have to get your life together because if you don't, somebody else is going to be raising your children, right?
Yes,
And I always tell people a mother's love is different from other person's love. But if you have no plans on improving your life, don't come in and out of your children's life. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're
Thank you, Judge.
welcome.
May we be excused?
Yes.
Thank you.
Sarah Gutierrez.
Morning.
Good morning. How are you doing today?
I'm doing well. How are you?
Oh, I cannot complain. It's a beautiful day.
Yes, ma'am, it is.
The sky acts as though we're trying to get some cool weather. LSU won, so I don't know what else we can say about that.
They're rolling in just as much as everybody else.
All right, so on this case, all right, state is to make an offer. State, did you make an offer?
Yes, Your Honor.
All right, we're going to recall this in 2 weeks. In 2 weeks, you need to let the court know if you're accepting the offer.
We can do that, Judge, but in the meantime, I did want to bring something to the court's attention. There has been, I've been out the last month, but in my absence, there was some issues that arose from Ms. Gutierrez's case with her family, and she was recently released from Laurel Ridge.
Okay.
I believe, just based on some communications that have occurred, and just, I would like to be cautious. I would request if we could be referred for an evaluation for competency for Ms. Gutierrez.
Okay. All right, Ms. Ferguson,
Yes, sir.
on this case, give me a 45-day reset, and we need to refer her to Judge Carruthers for a competency.
We can do December 7th.
All right, and Ms. Ferguson, if you'll make sure that's filed.
Yes, ma'am.
All right, do you want the court to file that, or are you going to do it?
For the
Competency.
request for competency, I can file that later this afternoon if the court. if
Oh,
the court
well, they
wishes.
will file it later this afternoon.
Thank you.
All right, thank you.
Thank you.
Once you're welcome. Once you get the reset form, you're excused.
Yes, Judge. Thank you.
Thank you. Luis Camacho. Where's the attorney for Luis Camacho? Oh, sorry. All right, we're here for discovery on the body cam. Where are we on that?
So I did receive the discovery for body camera early on, Your Honor. In this case, the issue was that of witness names for information that was discovered on one of the body cameras. I guess the state can update. Well, I think they essentially hit a point in this case where it may require further investigation from the defense potentially, or maybe a motion. But in the meantime, the state has extended an offer. We would request, just given these circumstances, if we can be given a plea deadline for Mr. Camacho.
All right, Ms. Ferguson, if I can have a 30-day reset on this case for plea deadline date, and it's Camacho.
The 28th.
All right, we'll be back on November 28th. Once you sign the reset form, you're excused.
Yes, ma'am.
All right, thank you. Stephen Rose. Who's the attorney for Stephen Rose? All right, just have a seat. Jose Angel Ruiz. Hello.
How are you?
Oh, I'm doing great.
Yeah.
I'm sorry.
We're not gonna have enough room.
Hello. So we are here today for a jury trial date.
Your Honor, it was my understanding this was a status update. Because there was some discovery and I do need to inform the court that pursuant to 3914 and Brady, we learned some information this morning. We will need to interview a prospective witness. And so we're asking for another, at least two witnesses that we know. So we are asking for another discovery setting.
I'm giving you guys a jury trial date. This has been going on with discovery since June 9th, 2022. So it's been all this time for discovery. I realize defense attorney's been changed, but we were here for discovery in June. Then we had discovery in August, and that discovery was related to the autopsy, which I know none of you indicted a case without an autopsy, but that's neither here nor there. Then we come back in September. In September, another discovery issue with autopsy. Then we come back on December 1st. Then we have DNA comparison that needs to be done. Then we come back on February 3rd. Then we come back on March 2nd. Then we come back on April 4th. Then we come back on April 12th. Then we come back on May 25th. Then we come back on June 1st for a plea deadline date. Then it gets recalled for June 5th because we have this whole attorney issue. Then we come back on June 5th. It was supposed to be a jury trial, but then no, we reset it for October 3rd. And then we say, all right, we're going to recall for October 23rd. I granted a motion for continuance. And then this date is the day that we get a jury trial date. So whatever you all want to do on off docket, whatever y'all want to do in Brady, y'all want to talk to some witnesses, then y'all talk to those witnesses. But you all are getting the jury trial today, and you all need to handle whatever discovery you all need to handle off docket.
Judge, may I say something?
Sure.
Because I know when we hear that from you, it sounds like, what are y'all doing? And it really is a case that's not, what's the right word? It's simple. It's not simple. The discovery and evidence is evolving because of the complexity of it. Now, if these witnesses have exculpatory information, obviously we want that and we want time to deal with it. Right now, they don't know exactly what the nature of it is, but.
So here's my question. When were these witnesses discovered? And did these witnesses just drop out of the sky, somebody indicting cases without
But they don't.
talking to witnesses?
They.
Your Honor, this particular witness, I believe,
Yes, he was a fugitive judge. I did personally indict the case. I did have an autopsy for the record when I indicted the case. However, this witness, no one was able to find him to interview him. He has now since picked up criminal cases. This morning, we were able to meet with his attorney. We have not met with him. We met with his
So
attorney.
where is he?
He is in custody.
At the Bexar County Jail?
Correct.
So then those witnesses' statements should be able to be done this week. So next.
But that's taking it, you've got his attorney that has to talk to him and then make him available to meet with them. I mean, it all takes time, as you know.
Today is Monday. That needs to be done this week, or however you guys gonna do it.
And then there's another issue too, which is that we have, the discovery's massive. And we have, external terabyte number 1 that we have received. And we have external terabyte number 2 that was handed to us unopened and unviewed. And because of content, possible content on there, it was returned to the DA's office. Okay, so there's a second 1 terabyte hard drive that is not in the possession of the defense, but available to the defense to view. The fact that we can't possess it and we have to go to the DA's office to view it also is a time-consuming thing.
Oh, let me just tell you, the state is gonna be available whenever you all are available to go over there. And if you all wanna set a setting in this court to come down and view it, you can set a setting in this court to come view it. How long have you been in custody? A year and 10 months. This is going to trial before the new year. Miss Ferguson, give me a trial date for this case before the new year. How long do y'all expect this trial to last?
2 weeks.
All right, it's a 2-week trial setting.
I would say today's October 23rd, 22nd.
So everybody have all the month of November and the end of this month. What date, Miss Ferguson?
So it's December.
December 12th, Judge.
All right, December 12th.
Judge, is that not going to put us into Christmas if it's a 2-week trial?
Yeah,
They'll be here for Christmas. All righty, thank you all. Is the attorney here on Victor Della Vega? All right, Victor Della Vega. Hello, are you not hot?
No, I was really good in the sweater.
Oh, okay. All right, so what is happening on this case?
Yes, Your Honor, the state has made an offer of mental health PTD on one of the misdemeanor cases. Once we are going to ask for a reset so we can apply into that course.
Okay.
And once he gets accepted, then I believe this felony case is going to be TIC'd along with all the other thefts.
All right, Ms. Ferguson, so you're doing PTD in misdemeanor court?
Yeah, yes, Your Honor.
All right, can we reset this for 30 days for an update on the misdemeanor PTD?
And Judge, just to clarify, it's gonna be the mental health court PTD.
Yes.
Mental health court, okay. What date, Ms. Ferguson? Yes, it's for mental health. All right, we'll come back on November 30th to see where we are. Once your client signs the reset form, you're excused.
Thank you, Your Honor.
You're welcome. Ruiz, I think. Oh, yeah. Thomas Henson. Oh, just 1 second. Are you all ready to proceed on the motion?
Yes, Your Honor.
Yes, sir.
All right, is this going to be contested or no?
No, Your Honor.
All right, I don't have an. I do. All right, the court is calling 2022 CR 5859, State of Texas versus Thomas Nathaniel Henson. Could I have parties announced for the record for the state?
Zach Dunn for the state.
For the defense,
Catherine Valenzuela.
are you Thomas Henson?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes.
Are you the same Thomas Nathaniel Henson who was placed on deferred adjudication in 2022 CR 5859 for the offense of aggravated assault with a deadly weapon on September 15, 2022 for a period of 4 years?
Yes, ma'am.
State?
Your Honor, on or about the 11th day of August 2023 in Bexar County, Texas, the defendant, Thomas Nathaniel Henson, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
State?
And Your Honor, there's an agreement.
The other allegations?
There are none, Your Honor.
Are you waiving?
Yes, Your Honor.
All right. Any objections to the waivers?
No objection to the waivers. Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yeah.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor. We had an agreed recommendation to continue and for DDRF.
That is understanding, Your Honor.
All right. Probation, is that your recommendation?
Yes, Your Honor.
What is the wait time for DDRF?
Honor.
The wait time is 6 to 13 weeks. Do we have any other alternatives?
State ISF cognitive track, Your Honor, that wait time.
All right, but will that address the issue? Because DDRF, I'm assuming there's a mental health issue.
And Your Honor, that had been the first recommendation, then he did the tap about, and that's why we got to NDRF, but the first recommendation had been ISF cognitive.
All right,
Sorry.
no problem.
So yes, the original recommendation was for the state ISF cognitive track, but we did an updated tap while he's been in Bexar County, and the recommendation changed for DDRF due to the mental testing.
All right, so the new number 1, who is the complainant? I mean, what is the relationship?
She's been my girlfriend.
Girlfriend. All right, and are we doing no contact with the girlfriend?
I believe there had been, she did sign an affidavit of non-contribution. We did enter a plea to proceed with the treatment that he believes he does need, Your Honor.
All right, so I'm going to order no contact with that person. And then once his mental health is stable, we'll do something different. Do you understand? I'm sorry, you need to speak up. All right, so do you have anyone else that you can live with? Mother?
I wasn't just living with her. She was living. She was staying.
Okay, you're mumbling. I can't understand. I can't hear you in the court report. I can't hear you.
I wasn't living with her. She was staying with me. So.
All right, so do you have your own place?
Yeah.
So who were you living with?
Yes, sir. I was staying with my grandma.
All right, so you need to stop inviting people to live with your grandmother when she's already have you living with her. You understand? So were you supporting yourself at all? Or were you just dependent upon your grandmother?
I mean, I wasn't paying rent, but I wasn't.
Were you working? I'm sorry, I can't hear you.
Sometimes.
So that means that you're not bringing in a stable income and you're bringing somebody else into your grandmother's house. That's a big no-no. You understand?
Yes.
All right, probation, anything with Center for Healthcare Services or?
Your Honor, I think. And I know that the state waived and abandoned the other allegations. However, he last reported to probation in March. So that's a concern for us. Right before he absconded, he did produce one negative UA, the others were positive. He did not complete his hostility management course that was originally mandated. I think our concern would be that he would abscond again without actually getting the help that is necessary.
All right. Do you want to go to prison? Because we can do that. Then why are you behaving as though you want to go to prison by not reporting? That's the easiest thing on the planet to do. You're obviously not working, really. So you're just watching television with your grandmother or something, or putting a burden on her where she has to feed you, and then you're bringing a girlfriend into the house. That seems like all you were doing and not doing well on probation. Do you want to go to prison for up to 20 years? All right, this is what I'm gonna do. I'll deny the motion. There's to be no contact with the complainant, whatever her name is, give that to probation. So the complainant and condition number 1, you are not to have any contact with her. Do you understand? So as far as your probation is concerned, that relationship is over. Do you understand? Do you have any children with her? So that relationship is over. If you end up violating my order and having contact with her, you could potentially go to prison for 20 years. Do you understand? And we're going to do state ISF cognitive and substantive track. And then we'll see where that leaves us.
Okay, Your Honor, I do want to point out that the way that state ISF is being ran now, it's not a double track anymore. It's either one or the other.
We'll do cognitive.
Thank you, Judge.
And then after that, when he's released, we'll put him on GPS, partial for work, until further notice. And you to reside at your grandmother's house. You understand?
And Your Honor, for Mr. Hanson's benefit, what are you looking for, or what is the court looking for so that he could get off GPS? I mean, just so that he knows, like, if he's always reporting, attending.
Oh, he needs to show me that he's actually taking this probation seriously. If you're not taking it seriously, what's going to end up happening is a motion to revoke is probably going to be filed. And instead of you worried about GPS, you'll be looking at potentially 20 years in prison. Do you understand?
Yes.
All right. And see probation if those fees can be waived.
Thank you.
All right. Thank you.
Thank you. Thank you, Judge.
You're welcome. Annette Idrago. Who's here on Annette Idrago? All right, where is she? Have her come forward.
She's right here in custody.
All right, state on this case, my understanding she has a case, another case. And you all were going to be looking into that. Where are we on that?
She was, may I address the question?
Yes.
She was picked up on that this morning, Your Honor. There was a
Okay.
bond increase on the other case, is my understanding, for $100,000.
Mhm.
So I don't know if she's gonna make that or remain in custody, but either way, if I could just get a little bit of time to look at the new cases, you can call this back anytime.
All right, Ms. Ferguson, on Idrago, if I can have a 30-day reset, please.
November 28th.
All right, November 28th, and state at that time if you could tender an offer.
Yes, Your Honor.
All right, thank you.
Your Honor, can we do it the week before?
All right, Ms. Ferguson, can you put that the week before?
Thank you. Take my kid to Colorado.
Are you driving?
No.
Yeah,
My
that's,
in-law wants to go in an RV, but I don't want, I want to fly.
oh, okay.
That's perfect. Thank you.
All right, November 16th.
Thank you, Your Honor.
You're welcome. Okay, Orlando, if I could see you, can you put us on mute, please? Oh.
Briefly approach.
Just a second.
Okay.
John Henry Bueno, are we back on that? Yes.
Maybe a contested one.
No, I mean, I understand it was down for contested, but we were here for the email, so.
Well, apparently it's a phone that has all the information on that I need to see the communication.
All right, and do we know, one, what the phone is, and two, is the phone charged? Are we gonna have to charge it?
Your Honor, they are actually charging the phone right now in anticipation that this it needed to be produced. I would just need to, if it's going to be a true contested, I just need time to get the officer here with the phone.
All right, so when do y'all want to set this? How much time y'all need? Just to let the court
I
know.
just looked at it today, Judge. So
Okay,
it was special crime, but apparently they're too special to.
you're too special.
We'll handle this, okay.
All right,
Next week sometime?
well, I don't know if that's enough time for them,
Okay.
at least to,
Sorry.
what do you?
About whether we would, since it is a cell phone, my understanding, it was consensual, like as in the sense of the search. So
Okay.
that would just be a question. I don't know if that'd be an issue for defense, but
Well, I think they're making allegations that he was using the cell phone for this,
Well, I mean, is there going to be
Stuff and
objection? Because they're saying that the searching of the phone was consensual.
right, it may have been, but they're saying that there was communication on the phone that he was trying to hook up with people and stuff.
Okay.
He's disputing that aspect. So if he had a phone, that's another thing. If he's trying to hook up with these people, that's a different thing.
Okay, all right, Ms. Ferguson, can you recall that, is 3 weeks enough time for everybody?
Yeah, that'll work.
Can you recall this in 3 weeks for potentially a contested? All right, November 16th. Yes. Mr. Bueno, we're going to bring you back on November 16th and they'll have the cell phone here for you. Oh, just have a seat unless they're ready to take you back. Stephen Rose.
thank you, Your Honor.
You're welcome. Have a great day. All right, who's here on Stephen Rose? All right, so what is happening with this case?
Judge, I have an offer and I discussed it with my client and he wants to set the case for jury trial.
All right, this is possession of body armor.
Yes, sir.
State, how long do you anticipate this trial taking?
Pretty selection, Your Honor, probably 2 days.
All right, Ms. Ferguson, this is 2 days. Can I have a jury trial date, please? And it's criminal trial division. All right, we'll be back on December 5th for a jury trial. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right. And counsel, you need to sign. Oh, I do have the acknowledgement of discovery, so that's done.
Thank you.
Thank you. Once you get the reset form, you're excused. Jose Ruiz.
Okay.
Hello.
I didn't. Are we on the record, Judge?
You want to go on the record? We
Yeah.
can.
Uh-huh.
All right. Court is calling 2022 CR 4248A, State of Texas versus Jose Angel Ruiz. Can I have parties announced for the record for the state,
Brittany Mitchell and Marissa Giovanco for the state.
for the defense?
Lisa Connolly and Lorraine Efron.
All right. And are you Mr. Ruiz? All right. What would you all like to put on the record?
That in conferring with the state today, it's come to our attention that there's the possibility of some newly discovered Brady exculpatory evidence. And I understand that the DA's office needs time to work out arrangements with the attorneys representing the individuals who have the evidence and to turn that over. And so we want all of the Brady and exculpatory evidence that we're entitled to, and we want an appropriate amount of time to deal with that. At this moment, I don't know how much time we would need to deal with it because it's not in my possession. But That was one thing. And then the other thing is that there are some pre-trial matters that may require some rulings, such as a motion to suppress oral and written statements. Now, we're going to confer and see if we can reach agreements on redactions, but it's possible that we're going to need a pre-trial hearing on some pre-trial matters. So I don't know how the court wants to handle that.
All right. So with regards to the communication with this witness, you all can pick up the phone, call the defense attorney, ask the defense attorney, hey, are you able to come to the 187th this week? And guess what? We will have whatever witness y'all want brought over at that attorney's behest, and y'all can talk to them in court in the afternoon. This jury trial is going to be set for December 12th. With regards to any motions to suppress issues, you all can come back all this week and see if y'all can agree on something. If you can't agree on something and you all want to have a hearing, a pretrial hearing on any suppression issues, Ms. Ferguson, can we set those pretrial matters for, let me see. If you can set those pretrial matters for the week of November 13th. So if anybody has some suppression issues, anything that you want heard, state, Ms. Ferguson will give you a pretrial setting for the week of November 13th, and everybody's to have their witnesses here.
Okay.
All right.
That sounds good. And we'll do our best to confer on everything that we can, and
Okay.
whatever needs to be resolved, we'll present.
All right, awesome.
Okay.
Thank you. Alicia Marino.
We can bring it up that day. November 13th.
Hi. Hi, excuse me.
Okay.
Let's call another case. Come forward, Alicia Marino. And probation, this is an application. Court is calling 2022 CR 6082A, State of Texas versus Alicia Marie Marino. Can I have parties announced for the record for the state?
Yes, Your Honor. Luis Echeverria for the state of Texas.
Defense?
Andrea Matos for the defense.
Are you Miss Marino?
Yes, ma'am.
Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Miss Marino, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes.
And did you sign it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to waive and abandon counts 1 and 2, proceed solely on count 3, state jail felony, Your Honor.
Any objection?
No objection, Your Honor.
All right, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on count 3, which is theft $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from up to a $10,000 fine, anywhere from 180 days up to 2 years in the state jail facility. Did you understand? If you have a plea bargain agreement with the state and the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 3. There's a $500 fine. State recommends deferred adjudication, and there's to be restitution to whom?
Judge, it's to, well, it's gonna be both to the Texas Lottery Commission. And that amount,
You all did not put that in your agreement.
well, Judge, I want to leave it open so that probation can ascertain it, but according to the prosecution guide, it is 1,870 to the Texas Lottery Commission and 2,929 to Easy Mark. Would you like me to write that
All
in,
right.
Your Honor?
Yes, you all need to write in here, not necessarily the amount if you don't agree to it, but to the parties.
Can I may I approach?
Yes. All right, thank you.
Thank you, Your Honor.
And also there's to be restitution, if any, to the Easy Mark and the Texas Lottery Commission. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 50 hours of community service restitution, no contact with Easy Mart at 415 Southwest Loop 1604 East, and the theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged in count 3, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, the state moves to offer into evidence state's exhibit number 1 and all attachments.
Any
No-
objection?
No objection, Your
All
Honor.
right. Ms. Marine, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly, voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding the guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would just ask that you follow the agreement that we've made with the state and give her deferred adjudication.
All right. So how old are you?
36,
Do you have any children?
2,
Ages?
13, and 16.
Are you currently employed?
Yeah, full time.
All right, what do you do?
I work at the TJ Maxx warehouse.
If you're tested today, what are the results going to be?
Negative, positive.
All right, what are you going to be positive for?
Marijuana,
How often are you using marijuana?
a few times a week.
Why?
It helps me sleep and helps me with my anxiety.
All right. Well, when you're on probation, you're not allowed to use marijuana. You understand?
Yes.
So do you have a diagnosis?
No.
So you're going to have to stop using marijuana. All right. This is what the court will do. The court will sentence you to 4 years deferred adjudication. There's to be a $500 fine. Excuse me. $500 fine probated. Restitution, if any, to Easy Mart, that's Easy Mart, and the Texas Lottery Commission. 50 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the restitution hours will be deemed satisfied. They want you to have a theft class. Look, here's my theft course for you. Don't steal, don't take what doesn't belong to you. That's it. If you take something, you need to pay for it. You understand?
Understood.
All right, there's going to be regular reporting by Zoom or in person. Could we do a referral to Center for Healthcare Services and a MIC evaluation? And it's going to be regular UAs, and I'm going to want her tested for levels. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. We'll do field visits 1 time per month until she is either with Center for Healthcare Services or in the MIC caseload. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. You're going to have to do better. Fast money is not good money, okay?
Yeah.
All right.
understood. Thank you.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you. Your Honor.
Once she talks to probation, they'll excuse her.
Yes.
Thank you. All right, I think we're done with John Wayne now. Okay. Arturo Villanueva. All right, counsel, where are we on the immigration issues?
That's been resolved, Your Honor.
Okay, thank you. So today is the plea deadline date. So what are we doing? Jury trial?
We're ready. We're ready with the exception of one thing, Your Honor.
Yes.
The state just this morning presented me a motion to amend indictment, which is not file stamped, and I think I'm
Yes.
entitled to some time on that.
10
Oh,
days,
yes,
Judge.
yes.
I filed that this morning, Judge. Sorry, I didn't mean to cut
No,
anything
no.
off. I filed that this morning. I took a look at the indictment. It alleges that the complaining witness was in a vehicle and he's not. So I amended that this morning. I e-filed it. And I served the defense. I don't know if he's received it yet, but he's on the e-file. I put his email address.
Okay,
My
all
response to that, Your Honor, if I can, is that it's not timely and we're ready to pick a jury today.
right, we don't do jury selection today. So.
It was a jury
Yes, sir.
setting though,
Yeah.
so.
All right, Ms. Ferguson. How long are you all expecting this jury trial?
We have 2 to 4 witnesses, Judge.
All right, Ms. Ferguson, they have 2 to 4 witnesses. It'll probably be 3 days.
I think December 12th.
We already have the other case for December 12th. So we already know that case is going to go, not this one. But we'll put you on December 12th and we'll see where you land.
Oh, no, I'm
sorry,
December 5th, Judge.
All right, December 5th, counsel.
Can I just check Your Honor real?
Yes.
Okay.
All right, we'll be
Thank
back on
you.
December 5th.
Judge, while we're here, do you want to, is now a good time to take up the motion to amend the indictment, or do you want to do that on the 5th?
You can get another date from Ms. Ferguson for us to do that.
Okay.
But we'll do it before December 5th. And it'll give counsel a chance because he hasn't had a chance to review and figure out if he wants to object or what he wants to do. So if you'll get a date from Ms. Ferguson for the actual hearing on that, if you wish to have one, just let us know.
Thank you, Your Honor.
All right. So once you sign the reset form for the trial, and counsel, just so you know, today was set for a plea deadline date, but I understand why you wish to go. All right, we'll see you back on December 5th for jury trial. Victoria Hernandez. All right, hi, counsel, come forward. You had filed a motion to enter adjudication of guilt, correct?
Yes, Judge, and I conferred with the state about it. I'm asking for a reset because my client wants to maybe have me make one more, she's in drug court.
Okay.
Make one more stab with Judge Glenn and see if we can't work out a resolution of her before she goes this ultimate step.
All right, so then we will take it off the docket. And you just come back and ask Ms. Ferguson when you want it placed back on the docket.
Okay, good. I just want to make sure we don't lose her spot because she's sitting in custody and. wants to-
Oh, we can bring you over whenever you want to be brought over. Just talk to Ms. Ferguson.
Okay, thanks.
Norma, on Victoria Hernandez, the defense is asking that that motion not be heard today. It's on the recall. Vashon, on Hernandez on the last page, they're not hearing that.
Hernandez on the last page.
Yes, they're not going to hear that. Carlos Ruiz and probation, this is no application. Court is calling 2023 CR 7288, State of Texas versus Carlos Edward Ruiz. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Stephen Gilmore for Mr. Ruiz.
And are you Mr. Ruiz?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ruiz, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
You do, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on count one, Judge, waiving count two, and then waiving the repeater enhancement allegation.
Any objection?
None, Your Honor.
All right, Mr. Ruiz, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count one, you're charged with the offense of intoxication assault? That is a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at a cap of 8 years in the prison. There's a $1,500 fine. There are no applications, and there's restitution, if any, to Judas Sanchez. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states exhibit one in all attachments.
No objections.
Show you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing or no?
We asked for PSI, Judge.
All right, Ms. Ferguson, can I have this set for a PSI, please? And we'll need a TAP evaluation. All right, so we'll come back on December 11th, and at that time, I'll make a decision on your sentence. Do you have any questions about anything?
No, ma'am.
All right, so we'll be back on December 11th.
Thank you, Judge. May I be excused?
Yes.
Appreciate you.
I'm a Deion Smith. Smith.
Judge, he's in custody.
He's still downstairs, Your Honor.
All right.
I just wanted to get the case scheduled. This is what I got from jail. There's a suggestion of incompetency.
I think maybe, Judge, it might be a good idea to get the defendant evaluated.
There he is. He's coming out now.
All right, Norma, we need an evaluation. And Norma, if you could file it. We need an evaluation, and if you could file it. What's date?
I'm sorry, we can do December 12th.
All right, Mr. Smith. Hello, how are you doing?
Good.
All right, we're gonna schedule an evaluation for you to make sure that everything is fine with you. So we're gonna bring you back on December 12th, but if everything is, I'm sorry,
I already
yes.
had an evaluation.
Oh, you've had a competency evaluation? When did you have that?
About 2.5 weeks ago, when I was upstairs on 5th floor.
Okay.
I'll look into that.
All right, Norma, let's do this. Give me a date for him in November, the second week in November.
Can I get a PR bond or something? And I already had an evaluation.
Hold on.
November 13th.
All right, so this is what will end up happening. If your attorney wants to file an application for a PR bond, he can file an application for a PR bond. I'm not your attorney. I'm not allowed to do that. So your attorney will have to file it. And if your attorney files it today, we will have it heard tomorrow. Do you understand?
So let me out putting off my court date until when?
November 13th.
There's nothing I can do to go home today. I mean, I already had an evaluation.
Okay. All right, Mr. Wolf, you want to speak to your client and see if he needs another evaluation?
I'll talk to him.
All right, thank you.
Will I be able to talk to him? I know
Sure.
you have court going on.
Jeremy Garcia. All right, thank you. And probation, this is an application for deferred. Hello, good morning. I'm gonna need you to make sure that you speak up because we have a lot of things going on here. Mr. Wolf, you're gonna have to be moved down to the end. So if you'll wait to talk to your client once we're off the record, or if one of the attorneys finish speaking to their client, okay? All right, court is calling 2023 CR 7562, State of Texas versus Jeremy Ray Garcia. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Adam Coontz for Mr. Garcia.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And
Yes.
did you sign it?
Yes, ma'am, I did.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am, we are, Judge.
We're on the record. All right. We are on the record. Counsel, I'm sorry, Mr. Garcia, showing you what's entitled court admonishments and defendants waivers and admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
All right, did you understand you're charged with theft of a firearm? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application of deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes and yes.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, state recommends deferred adjudication. They're taking in consideration 712-934, 716-716. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I have.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and no harmful or injurious contact with Alicia Gonzalez. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I do.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments. We reviewed them and have no objections, Your Honor.
All right. And with regards to the no harmful or injurious contact with Alicia Gonzalez, she's aware of what's happening and that is what she's requesting?
Well, ma'am, another prosecutor's spoken to her and based on the notes in JD, it seems to be what she's requested, Judge.
All right, thank you. You may be excused to continue to confer.
Thank you, Judge.
Mr. Garcia, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, I have.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, please.
Anything you wish to say on behalf of your client?
Judge, obviously, we're requesting you follow this plea bargain. He made a terrible mistake a couple of years ago when he needed some money. He was in a downtime in his life. He has several small children. And he's very apologetic and is very grateful for this opportunity. I've explained to him how important it is to successfully do everything on probation, and that if he does well, that there's a potential that his probation could be terminated early. He understands that. He is looking forward to getting back with his family. He has been in custody this current time for about 2 months already. So he's looking forward to getting back and going back to work and trying to help support them.
All right. Is there anything you want to say?
Just that I am grateful for this opportunity. I just really miss my kids, so
Well, it's your fault.
yes, ma'am.
All right, this is what the court is going to do. 4 years deferred adjudication, no harmful or injurious contact with Alicia Gonzalez. Take in consideration County Court Cause number 712-934, 716-716. Are you currently employed?
Yes, ma'am.
Doing what?
We put in office supplies for Cox centers.
Okay. So nothing like before.
You're not going to gun shops or anything like that, are you?
Oh, no, I was installing security cameras at the time.
So I'm assuming nobody's using you to install security cameras anymore.
No, ma'am.
Okay.
Unfortunately, no.
Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. Regular reporting by Zoom or in person. Regular UAs. Field visits. 1 time per month for 3 months. Probation, if there are no issues, then you can discontinue field visits or as you deem them to be. There should be 80 hours of community service restitution. I'm going to order parenting classes. Once you completed the parenting classes, then your community service hours will be deemed satisfied. Probation, is there anything else he needs?
No, Your Honor.
Is there anything else you need from me?
No, ma'am.
Nobody requested a theft course, so I'm going to give you your theft course. Don't take what doesn't belong to you. If you're taking something, you need to pay for it. Do you understand?
Yes, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record from here on out. You need to be trying to make your children proud of you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge. Thank you.
Thank you. Jose Ruiz, why do I keep getting this file back?
Oh, Lorraine actually had to run to the 186. I'll text her and let her know.
Okay. All right, we're done with that file. Kevin Corral. All right. So today is discovery day on this case. Where are we on discovery?
I think we've received it, Your Honor.
Okay. And has an offer been tendered or no?
Just as we speak, earlier this morning.
Okay.
And so we haven't had a chance to confer with my client regarding the offer.
All right, Ms. Ferguson, can you recall this for 30 days for a plea deadline date? All right, we'll come back on November 30th. At that time, you need to let the court know whether or not you're accepting the state's offer. Do you understand? All right, thank you. Once you sign the reset form, you're excused.
Okay,
but that one's done. Paris Ferris,
He's still downstairs, Your Honor.
they still have your client downstairs.
We're still waiting on a competency on this one, Judge.
Oh, you are?
I haven't received a report yet to see that they've completed their evaluation.
All right, let's do this. Let's make sure we get him out here so he can know what's going on, and then we'll get a date and everything.
Yes, ma'am.
Carlos De Leo. All righty. Where are we?
Trying to pick a side here.
Okay.
Morning.
Good morning. Well, y'all have the brains of the operation behind you.
I know.
That's what I'm saying.
I'm over here on the side.
Okay. All right. So where are we on this?
The last hearing we had, we've got some results back from Houston Forensic Science Center, and we were requesting the underlying data to support those findings and conclusions. We've received that.
Okay.
I am in the process of giving that to my client and to our expert for analysis. Unfortunately, for my purposes, my client is not able to look at anything digitally, and it's a whole bunch of stuff digitally. And so I've got to put that all out, get it over to my client and to our experts. And
He can't listen. He can't look at anything digitally. Okay.
No PDFs. Yeah.
All righty.
So that's where we are. And we're in the process of trying to get all that done. And I'm hoping that once we get that analysis looked at and done, we can get an expert opinion back on that and be able to proceed and go forward.
All right. How long are you all anticipating this? Because this is one where there is a conviction and we're just trying to see if that conviction is a proper one.
Right.
So
Matt and I were talking today, and we're thinking at least 90 days, maybe even 120, get us through maybe February before we're going to be able to have an expert review. It's a ton of stuff, Judge.
Okay.
It's just a ton of stuff. And so we've got to figure out it just.
And your client is not in prison.
He is in prison. On this one, he's in prison. The other one, he's not. He's actually out on parole.
All right. So which prison is he located at? So would it be easier to have him bench warranted back here? I know there's an issue with the time. Would that make things run smoother?
No, not really. I mean,
Okay.
because really what we're looking for is our expert analysis on the underlying data and the results that were obtained from.
Well, I mean, I know because you said he needed to review things. I'm wondering if that would make it easier. If not, then it won't.
Knowing my client, he wants it. He wants the actual results.
No, I mean, bring him here
Right.
and he can look at whatever you wanted him to look at. But if you all don't think that will make things run any quicker, that's fine.
It's not, Judge. I
All right.
appreciate that, though.
Sure. Ms. Ferguson, they're asking for 120 days. Normally that's never done, but okay.
It's just that we're not wasting the court's time coming back.
It is never a waste.
We're still working on it.
Okay.
And Judge, so the court's aware, the state is prepared to, I mean, the final piece of the puzzle here is that 6404 hearing.
Mhm.
We're prepared to move forward on that, but I mean, the big issue here is that Mr. De La has to carry his burden. We want to be able to, we want to give him as much time as possible, give Mr. McLean as much time as possible to review documentation here, basically be ready to have that final hearing. So really the last statutory requirement on the court is that 64
Yes.
hearing.
And no, we'll have it. And I want to make sure that everybody has everything that they need to go forward.
February 22nd.
All right, we're going to come back on February 22nd, 2024. Time has gone by quickly.
All right, we will do our level best to be ready on that day, Judge.
All right, thank you. You're welcome.
See you then.
Nicholas Ramos.
Minutes.
All right. So how many cases are we proceeding on? Just one, okay. All right, court is calling 2023 CR 3133B, State of Texas versus Nicholas Ray Ramos. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
You're on that side.
Anthony Cantrell for the defendant.
And are you Nicholas Ray Ramos?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ramos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged by indictment with aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Okay, according to the plea, punishment is to be assessed at a cap of 16 years in the prison. There are no applications. This will run concurrent with County Court Cause number 6915448, 6915449, 694250. And there will be several cases taken in consideration. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Good.
State any evidence?
State offer states Exhibit 1 and all attachments. No objection.
All right, you may continue. First, showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. This will be set for sentencing on December 7th. We'll schedule PSI. And even though he's not applying for probation, I am going to schedule a TAP evaluation that'll give me some idea.
Thank you.
Is there anything else, counsel?
No, Your Honor.
All right. We're going to come back on December 7th. I'll make a decision on your sentence based upon any other evidence that's presented to me in the TAP evaluation in the PSI. Do you understand?
Yes, ma'am.
All right, thank you. And the state tendered some dismissals, so I will give those to you.
Ready.
You're welcome.
We'll do this over there.
Sure. Good idea. We'll see you soon. Set up a visit.
Your Honor, Lorraine gave me the okay to go ahead and approach you on the last.
All right, just give me a moment. Jesse Solis. And just one moment, let me have you all step back for just about 3 minutes because probation is in the box and this is a probation case. Oh, you ready? Oh, she's ready. Okay. Court is calling 2020 CR 0298, State of Texas versus Jesse Solis. Can I have parties announced for the record for the state?
Left hand for the state.
I think that is for the defense.
And are you Jesse Solis? All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Jesse Solis Jr. who was placed on deferred adjudication in 2020 CR 0298 for the offense of assault family second offense on August 24th, 2021 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. On or about the third day of September 2021 in Bexar County, Texas, the defendant Jesse Solis Jr. did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State?
Your Honor, the state would move to deny the MTR and modify.
Are you waiving the other allegations?
Your Honor, I appreciate it. Yes, we are waiving and abandoning the other conditions.
Any objections to the waivers?
No objection, Judge.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, there is a proposed agreement for SADF.
Probation? Is that your recommendation? Because I have 2 questions. 1, is that your recommendation? And 2, has he done anything on probation?
Your Honor, the original recommendation was for Bear County ISF followed by ISP. However, speaking with defense counsel, she indicates that Mr. Solis may have a drug problem. Kind of looked over that, then we said SADA. My other thought was revocation. His last office visit with probation was February 18th of 2022. Your Honor, he has not completed anything on his probation. He did initially signed up for the Veterans Prevention Program, but we don't have anything on file that he actually completed it. And then he has not completed any of the other terms.
All right, has your client done anything on probation?
No, I don't believe he has, Your Honor, but I did have my visit with him. He informed me and I spoke to his mother as well. He had a stroke in 2008. And so he's got some memory problems that are nowhere in the court's records. He's had some auto accidents in 2011 and 2012 where he's got hit by a car. And the mom did confirm the memory problems. So I did have my visit with him, he knows he's on probation. He knows he was on probation. He absconded. I obviously asked him why, and he let me know that, that he does have a drug problem and he does want help. And he's asking the court he's not a convicted felon judge. That's why he's on deferred. So this is his first MTR. He's never been on felony probation before. He's got some misdemeanors, but he's asking the court to allow him to get some help. He's 39 years old.
All right. Mr. Solis, the court's problem is that you have not done anything. All right, this is what the court is going to do. Court is finding violation of condition number 2 true. The court is going to grant the motion, find you guilty. Revoke. Does anybody wish to speak to the time?
Nothing from the state, Your Honor.
All right, defense, do you want to speak to the time? The range of punishment is anywhere from 2 to 10 years in the prison.
That's correct, Judge. So in light of the fact that Mr. Solis is not going to be, given an opportunity to continue in his probation, I would ask that the court give him the minimum sentence.
All right. Court is finding violation of condition number 2 true. The court will find you guilty, grant the motion, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Ana Solis and Gloria Torres. There's an affirmative finding of family violence. If you would like the therapeutic community, I can request that, but you'll need to request it as well. So if there's a drug or alcohol problem, they will address those issues with you. Would you like that?
Yes, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. This was not a plea bargain agreement. You do have a right to appeal. That right to appeal is limited though to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes.
All right, good luck to you.
Thank you.
Oh, and I'm sorry, one other thing, because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Thank you.
All right, good luck to you, sir. All right, court is calling 2020 CR 2127, State of Texas versus Gabriel Maurice Gobert. Who's the attorney?
She just stepped out. She said she's number one in impact with Judge Angelini.
Okay. All right, we'll come back for that.
I'll text her.
Rogelio Laura. Hello. All right, on this case, the state was to tender an offer today. So has that been done?
Yes, ma'am.
All right, how much time does your client need to consider the offer?
I mean, just a couple of weeks, Judge. I'd like to be able to talk to him at length about the offer.
Sure. Ms. Ferguson, on this case, can I have a 2-week reset for a plea deadline date, please?
Yes, I can do the 13th.
All right, we'll come back on November 13th. Once you sign the reset form, you're excused.
Thank you.
You're welcome. Has Paris Ferris been brought up? All right, let's come forward. Hi, Mr. Ferris. We're just waiting for an update on your evaluation. So it's taken a little bit longer than anticipated because they have a backlog, all right? So Ms. Ferguson, what date do we bring Mr. Ferris back?
We can do December.
All right, we're going to come back on December 5th, no later than that date. But if everything is done before then, your attorney will let us know. We'll bring you back before then, okay? Do you have any questions about anything? All right, thank you.
Thanks, Judge.
You're welcome. Remember, which page is he on?
He's on the MTR page.
All right, thank you. Jose Ruiz.
Yes, Judge.
Yes.
This is just I don't know that it really involves defense, but Lorraine did tell me she was okay with me addressing you.
Sure.
One of the witnesses that we were referring to this morning, obviously one of them is in custody. The other one is not in custody, but based on the information we learned this morning, I think we need to get an attorney appointed to her.
Okay.
So I just need to logistically.
All
ask
right,
them.
Ms. Ferguson. They need an attorney appointed for one of their witnesses.
I need the name of the witness, the sit number, case number.
Okay, she doesn't have the case, but I'll give you the number.
Thank you.
All right. It is 12 p.m. So some things are about to happen. Could I see the file on Raul Paral?
Judge, that one that has approached you last week and asked for 3 o'clock on Thursday, and you gave him the approval.
Okay. All right.
Judge.
Yes.
Mr.
Okay, all right, thank you.
And
We
we
will
have
take that.
BTC here too.
Okay, thank you. All right. So is anyone else attorney other than the people here for Chrisman? Any other attorneys that are ready? Who do you have? All right. Well, Mr. Leal, you're sitting there, but have you asked, is your case a plea or something?
No, Your Honor.
Well, have you asked the clerk to put the file up here?
Yes, I have.
Well, no, because if you would have asked, Caroline is very good. She would have had that file up here. Caroline, was a file asked to be placed up here for you? All right, that's a no.
Well.
So she
that's
did
a
it now.
yes, because I asked the court coordinator to do that.
No, the clerk does. I always tell everybody, I always tell everybody to stay in their lane. So the clerk has her job. I have my job. All right, Miss Jenkins. All right, Miss Ferguson, we need a jury trial date for this case.
Your Honor, if I may,
Yes.
my client has a prior case back from 2021. And also she picked up a new case this year in May of this year. I haven't had much time to review the latest case. I discussed the matter with Travis, and we're trying to work both of them out. And we think we can get a plea by the next time, but he needs to speak with the complainants in these cases.
All right.
That's partially the reason. Additionally, Judge, in the prior case, she's remanded with a bond. The prior bond was 35,000. I'm asking that the court set a bond on that case.
All right. So State, which case are you going on for jury trial? The 2022 CR 3280 or either the one that I have before me, which is 2023 CR 6843?
Well, I mean, the better trial case is gonna be the 2022 CR 3280. But that's not the case that I'm working on.
All right, Ms. Ferguson, I need a jury trial date. How long is this trial gonna last?
Probably 3-4 days.
All right, yes. Family violence, 3 to 4 days.
The 2022 CR is the CTD case. Our case probably would not be the one that goes to trial, Your Honor.
All right.
So if you,
Well, just one second. CTD. This is Latasha Jenkins on the 2022 CR 3280. Are you all going to trial on that, or have you all conferred with Mr. Leal?
No.
All right, so you all need to confer.
Well, I tried to confirm with him, and he referred me to the new case.
Yeah, I made an offer on the new case. I just increased the old offer that they had on.
Okay.
So technically, I did.
Case.
All right, but now he's saying that if it goes to trial, it may be criminal trial division. So I think state defense and criminal trial division, you all need to talk to see if that's actually the case, because otherwise the case that's going to trial is 2022 CR 3280. Because that's the oldest case that the court has.
That's the CTD case.
Judge,
Okay.
And if the court will set a bond on the older case, I appreciate it.
All right, so you'll need to file a motion. And then Ms. Ferguson, I need a jury trial date.
There is a motion on file, Judge.
Okay, so, all right, so December 5th is going to be your jury trial date. So one of these cases is going. All right, and if you'll talk, Ms. Ferguson, his request for a bond, if you'll forward that to Judge Nahara, please. All righty, we'll see you back on that date
Thank you.
for your jury trial. And that will be a jury trial date, Mr. Leal, and a plea deadline date.
Thank you, Judge.
You're welcome. All right, Crispin.
Put a couple of things in the file for you to look at.
Okay, let me look at that real quick. Sorry about that. Let me check very quickly. Oh, right. Okay. So where are we?
Your Honor, the last time we met here, you asked the veteran to provide information claiming his veteran status. Unfortunately, as the felony VTC is concerned, we still do not have a DD 214, a VA card, a service letter, anything at all regarding to any type of military service. I did receive a text message from Mr. Chrism on Friday explaining that a date of birth might have been put in wrong somewhere within the governmental system. I did follow back up just in case it did occur with the VJO who did the assessment for Mr. Chrism. I spoke to both of them. They stated that they asked him personally for his date of birth. And when they did go through the DoD records, they're still coming up empty on the fact that there was no military service for anybody under the last four of his social or his date of birth. Your Honor. So unfortunately, as of now, we're still where we're at.
All right, so probation, what are our plans for Mr. Christmas? Because I don't think the military issue is ever going to be resolved. I know you can look at it online, and I know you all have been online and it's not there.
Yes, ma'am.
And I know that there was a fire, but the fire he's speaking of is not a fire at the facility that holds the records, correct?
Correct, ma'am. He's speaking about a fire that occurred at his home. I do believe your residence off of, I'm blanking on the address, but the one where you lost your two dogs.
Yeah.
Okay.
So
So-
that occurred in the fire at the military facility he did talk about last time. He was too young to have happened for his records.
Okay.
Your Honor, so I think one of our major concerns is Mr. President continues to use alcohol. So that's our major concern at this point. The original thing was, him to try to get the services to get to where he has a more supportive base, but at this point.
Because here's my concern. I don't like sending, for want of a better word, problems to somebody else. So to me, sending him to California would be sending a problem to California. I just don't see how that's the answer.
I know the last time we were here, Judge, Mr. Chrisman did have he did ask about some treatment. So maybe the treatment that he was or leaning to, we can look further into. I know that there was an outpatient treatment and then there was an inpatient treatment.
All right, is there a treatment available for him maybe at Lifetime Recovery?
I could check with Lifetime, see if they have any beds available.
All right, Mr. Chrisman, Lifetime Recovery will be able to help you. I don't like sending what's considered a problem. I don't like farming work off to other people and say, oh, we can't solve this problem. So here you go. Good luck to you. And I don't think it will be fair to you or right for me.
California.
Yeah, I don't think it would be fair for me or fair to you to send you off to California. And I don't even have any, much like your military records, I don't even have any documentation from California saying, oh, this is my support staff or supportive group in California. I don't have any of that.
I have it, it's through Concord. You told me the exact opposite last time we talked, you
Yeah.
requiring this one direction.
But I have nothing. Everything that you, so far, everything.
Information today, it's got.
Well, here's the thing. So far, everything that you told me, I don't have any documentation for.
Because we were going down the one direction. I do have the information from Concord that I was accepted into an inpatient program in California through Aetna, which is my insurance.
But here's the thing, being accepted and actually being in the program, I don't know if I send you to California, you're actually going to go in the program. That's the issue.
I have to go in the program because then it would be, I'm still on probation in California. So they're going to relate it all together. So I
No,
have to go.
that's not the way it works. But if you want to give her that information, you can, and we can come back when we come back. But I want to see if Lifetime Recovery will perhaps accept him.
Yes, Your Honor. I'll check with them, especially with his medical issues. What was the other name? Remember the last time we were here? Oh, San Antonio recovery. San Antonio recovery may be another option, Judge.
All right, so we'll look into lifetime San Antonio recovery and also
Concord.
see about his California, but he has to provide documentation for that. And then it will be up to California whether they even accept you. People think when I say probation is transferred, that it's, oh, I wrote transfer and you're there tomorrow. That's not the way it works.
Yeah, they have to accept you.
All right, thank you.
Thank you, Your Honor.
Gabriel Gobert. All righty. So these are cases that are going to be recalled for tomorrow. Roland Diaz.
Yes, good.
Yes, what's happening with your case?
Your Honor, we did have an agreement, but Mr. Diaz doesn't wish to go forward with it at this present moment.
All right, Roland Diaz, come forward. All right, do you have discovery in all of the cases, counsel?
And Your Honor, if you may give me a moment, I'm trying to recall.
Okay.
I do not know if I've downloaded in all 4 aggravated robbery cases. I can inform the court later which ones I have, but there are 4 of them.
All right, so Mr. Diaz, we're going to schedule you for a jury trial, quick, fast, in a hurry. You understand? That's either yes or no. All right, so what I'm going to do is I'm going to recall this case back in 2 weeks. That's your plea deadline date. After that, the court will not consider any offers in these causes without good cause. Otherwise, you're going to be pleading open to the court. Do you understand?
Yes, sir.
So in this court, there is no, well, right now, I'm not going to do it. Maybe I'll do it on the day of trial. That's not the way we do things here. You understand?
Yes, sir.
All right, Ms. Ferguson, I need a plea deadline date in 2 weeks for Mr. Diaz.
That's including the NPR, Judge?
Yes.
November 6th.
All right, we're going to come back on November 6th.
Your Honor, if I may, just for housekeeping purposes, I have not had the opportunity to confer with the state that Mr. Diaz has not had a change of heart, but is hesitant.
Okay.
So I do not know if the current plea bargain offer is open, and I've informed, will remain open for that date, and I've informed Mr. Diaz of that.
All right, state, will you keep the offer open until November 6th?
Yes, Judge.
All right, the offer will remain open till November 6th.
Thank you, Your Honor.
Right, although I did do research, and do you know, with regards to plea bargain offers, the state can close it at any time before acceptance.
Fortunately, we have assistant district attorneys of such high character.
We
that
do.
I know that that's not a.
That's not going to happen.
Yes, Judge.
And now that you said that, they most definitely cannot do that. All right, thank you.
Thank you. That's been my experience in my 30 years of practicing. Judge.
Yes.
Thank you, Judge.
All right, so Gabriel Gobert, when do we want to call this back, Norma?
Tomorrow.
All right, Mr. Gobert, if you come forward, we're going to bring your case back tomorrow. Your attorney's in the trial, and maybe that will be taken care of, okay? Thank you so much. They'll give you a reset form. Yes.
You can have a seat, sir. We'll be with you in just a few minutes.
Yes.
Mr. Goldberg, there may be a supplemental motion to revoke
Okay,
submitted.
okay,
Can we push it out a little bit further?
yes. All right. Mr. Gobert, come back, please. They're saying they may do a supplemental motion on you. Are you employed?
Yes.
All right, what is your work schedule?
I work about 27 hours a week.
What days?
I get every other day. Like I work, like say I work today and I get tomorrow off, then I work the next day, and it goes like that.
Okay. All right, so what we will do then is if we call you, when's your next off weekday?
Like a week?
Yeah, when is your next off day?
Tomorrow.
Okay, so we're not going to set it for, We're not going to set it for tomorrow. So we're looking at November, probably the week of November 6th. So that's 6, 7, 8, 9, or 10. What date would you be off? Do you know?
I work afternoon, so I can come in the mornings.
Okay. All right. What day the week of November 6th? Oh, November 6th?
Yes, ma'am.
All right. So we'll bring you back on November 6th
Okay.
and they'll give you a reset form.
Have a seat, then be right with you, sir.
All right. De Hoyos, we'll bring that back tomorrow. And then Mario Miranda, we'll bring that back tomorrow. And then I have Kevin Corral. Oh, that's done?
Yes, ma'am.
Okay.
November 30th for deadline.
All right, thank you. All right, and I think that is everything.